Welcome back to this second part of this law session on public law in relation to the royal prerogative. Now, immediately before the break, I left you with a working definition of exactly what to consider when you look at the royal prerogative. What we are going to do now, of course, is continue in that same vein and look at this whole concept of the royal prerogative. Now, the UK has what is termed a constitutional monarchy rather than an absolute monarchy. And what this means is that the monarchy is apolitical and impartial. It doesn't take sides. One of the things about the monarchy is that it is there with a degree of continuity. So, for example, you get the Queen coming up to, her Diamond Jubilee. We get the Queen coming up to being in power, or rather, well, I shouldn't use a term of the Queen being present for the better part of 60 years. And the point, of course, is that she would have certainly seen throughout her time how different governments have approached certain political issues. She has been able to assist. She can give an impartial standpoint on this. And so the work that the monarch does is, by and large, largely symbolic when it comes to the political arena. So the work of the monarch within the remit of the royal prerogative is seen as being done in respect of the elected ministers. So when you look at royal prerogative powers, albeit that we have the royal in terms of prerogative, it is really that you get the ministers who generally carry out these prerogative powers. Now, in the 19th century, we get Walter Begge describing the monarchy as being symbolic and ceremonial and with little actual power. And when we talk about that, when we talk about the actual power, we're talking about actual political power. And certainly in the 21st century, we see this even more true, because when one looks even at various aspects of the exercise of the prerogative, and we will, as I say later on, get into more practical detail, but when you see how the prerogative powers have been exercised, they have by and large been exercised by ministers. So in terms of the symbolic and ceremonial view, it is that the Queen reigns but does not rule. And prerogatives, as we see, because they are the powers inherent to the monarch, it does not necessarily follow that they are exercised by the Queen. Again, it's all about the Queen reigning. So she reigns over the UK, but certainly the ruling part of it and the exercise of the prerogative tends to stay within the remit of her ministers. Now, returning to what exactly we're looking at here, as I say, the powers inherent to the monarch, which the common law actually recognizes as lawful, but it is by convention that they are exercised by the Prime Minister or the ministers. Now, all prerogatives are derived from, and certainly they are permitted, and they are indeed also limited by the common law. And the courts have jurisdiction only to examine the existence and scope of a prerogative power, firstly, and certainly when you come, if you return to the previous law session on separation of powers, we would have touched on that when you look at a prerogative power, and certainly when you look at the overlap between the executive and the judiciary, you see that with the scope of a prerogative power, the court can look at what it is. But once it is established, then the court must take judicial notice of it, just like any other rule of law, and the court needs to determine whether such a power is justiciable. So the court looks to see, is this prerogative power an actual prerogative power? Because as I've said before, it's not like you can get up today and decide, well, we're going to make a new prerogative power. But what it does is to say that once the court recognizes that there's this prerogative power, the next exercise of the court is it a type of power that the court can actually deal with. Is it justiciable? And remember, in separation of powers, we said if it is that it is high policy, no. But if it is that you are looking possibly at civil liberties and rights, then possibly yes. So the difference between a GCHQ type case scenario and the difference between a M Home Office type case scenario. So as it relates to prerogative powers in any event, it is said in the case of proclamations in 1611 that the king has no prerogative but that which the law allows him. Who is the law? Well, we go back to the legislative arm of the framework of the organs of the state. Equally, we see in the case of prohibitions in 1608, it talks about the king shall be beholden to no man but under God and the law. So we see that the law is still important in respect of even the prerogative powers. And what we will also see when we come to later on in this law session is the control of prerogative powers. How are prerogative powers controlled? And what we will see is precisely what has been set out in the case of prohibitions, that the king shall be beholden to no man but God and the law. If prerogatives go too far beyond what the law, meaning the legislature, wishes it to, quite easily Parliament can pass an act of Parliament in order to limit that. Now, as I said, we've looked at some of the prerogative powers, and we talk about the Queen being able to appoint and dismiss a minister and so on. But in the 21st century, we see that the convention of who is appointed the Prime Minister, for example, is more the reality being that it is the person who is the leader of the party who wins the general election. I mean, the Queen could get up tomorrow and say, she wants Jennifer Housen to be the head of England and Wales. But because that is her prerogative. She could actually get up tomorrow and say she wants me to run England. But the fact of the matter is that convention dictates who should get that post. Now, the fact is that it is after an election, the Queen will choose the leader of the majority party to lead the Commons. However, what happens if the Prime Minister refuses to leave, say, after he loses a vote of confidence? Well, it is slightly unclear, as it has really never happened in recent political history, but theoretically, the monarchy can exercise powers of appointment and dismissal. Now, bearing in mind prerogative powers, I want you to take on board and not let it be lost on you. What is the effect of this? Because given that you're looking at rights which can be exercised without input from the electorate, because these are powers exercised by the government, the Prime Minister and the Cabinet, how does this fit within the framework of democracy? Indeed, let's go one step further. How does this fit within the framework of the rule of law? Because here you are saying that there are certain powers which are being exercised which arguably cannot be affected by any person beyond the sovereign in relation to how the ministers exercise those prerogative powers. Now, the prerogative powers extends a little bit further, and the monarch certainly has powers to appoint peers, senior Church of England officials, the head of the BBC, senior civil servants. That still falls within prerogative powers. Now, in reality, though, they are actually chosen by the Prime Minister, and we see a somewhat limited type of prerogative powers which are left in the personal disposal of the monarch. So what we do see is that a vast amount of power with regards to senior appointments still rests with the Prime Minister exercising the prerogative power. Now, the Queen opens and dissolves Parliament, and as I say, of course, this is now subject to certain parliamentary enactment. She also approves all statutes of law. Again, that is her prerogative, that it doesn't become an act of parliament unless it receives royal assent. But in reality, it is unlikely that she would not give that piece of legislation her assent. Now, when we look at the date of a general election, generally set by the Prime Minister, used to be before, and the Queen, but this is now, of course, subject to the Fixed Term Parliament Act of 2011. We see also that it is a prerogative in respect of the Queen when one considers the state opening of Parliament. She simply reads out the proposed bill for the next 5 years of a government, but she does not play any part in deciding them. Now, as I said, when you look at the prerogative powers, it is not that, for example, the Queen is not going to, or the monarch as it may be, is not going to practically, by convention, do what they ought to do. So, for example, no monarch has refused to give the royal assent to a government bill, since 1707 anyway. Now it seems that it would be completely untenable that the Queen would refuse to sign a government bill which had passed the Commons, the Select Committee, the Lords, and the whole process that it entails in order to make a bill. It is highly unlikely that the Queen would not, for example, give it royal assent. Arguably, let's say the monarch didn't give the royal assent. Well, it would arguably spark off a major, if not the major, constitutional crisis, and theoretically the monarch would never do that. Well, theoretically they can do that, but in practice they would never do that, I should say. Now, theoretically, again, the monarch has the right to grant pardons, have input on some sentences, but in reality, it is the Home Secretary which decides this. So, for example, when you look at a classic example, like the case of Myra Hindley, and it may be, if you're not aware of it, something that you may want to go on the internet and have a look at. But the case of Myra Hindley and Ian Brady was a really sad case, because what you had here were two people who had done some really awful things to little children, and certainly included killing them. And this was somewhere in the early 60s or thereabout. And the general thing is, when somebody gets a life sentence in England, it doesn't necessarily mean that they serve a life term in prison. It generally means that they are unlicensed. So the average thing is, somebody gets a life sentence, they could easily be out of prison in, say, 15 years, but then they are unlicensed, which means that it is not spent under the Rehabilitation of Offenders Act. But in respect of Myra Hindley, Jack Straw, who was the Home Secretary at the time, said that life term would mean life in her case, meaning she would stay in prison for life. So we see that these kind of pardons and granting of mercy kind of thing is actually dealt with by the government minister rather than the monarch, him or herself. Now, the monarch, by way of proclamations or orders in council, may declare war or, of course, sign treaties without the input of the Commons or Lords. Now, in reality, the declaration of war and the signing of treaties is done by the Prime Minister acting on behalf of the Crown. Now, interestingly, when you look at the 2003 declaration of war against Iraq, this was done by a Prime Minister and not by the monarch. Now, when you look at it, the Prime Minister is democratically elected, and he's a politician accountable to the electorate via an election, whereas when you look at the monarch, it is no more than a position that has been arrived at by virtue of your birth. So there may be an argument that it is not a bad thing for it to be exercised through the ministers and the Prime Minister and the ministers, but the question then is, what about the political undercurrents? Well, we're going to take a short break as well at the moment, and when we come back, what I want us to look at is to consider, or to start off by looking at, the issue relating to the Iraq war and the exercise of the royal prerogative in that regard, immediately after this break.